plea than she would have gotten if this didn't happen.
Yeah. I just want to acknowledge that we are starting to get some attendees joining us. And while we're waiting for people to join, we'll give it another few minutes, but we'll kind of keep chit chatting. On another topic, did you see in the news about Mary Kate Olsen trying to file for an emergency uh, divorce?
We love when things like this happen. Yes. That request was denied.
Yes.
Lauren, what was the basis of the emergency again? It was like something about her not being able to get out of the house. Is that right? Something like that?
Yeah, I think there was a dispute between her and her husband, and she was afraid that she was going to be evicted. Like, not evicted is a poor word to use, but pushed out of the apartment, say, or pushed out of their marital home
because she had nowhere else to go.
And I think that was probably where it failed to rise to the level of an emergency.
Yeah.
You know, when you have access to a lot of money, you know, the courts tend to say, you know, that's not an emergency. You know, you can find somewhere else to live temporarily, and then we can deal with this in the proper timeline.
Yeah.
You know, and the courts right now are you know, reasonably operating at a very diminished capacity, and there are people who, you know, families that do have real emergencies.
Yeah.
Right.
Yeah.
That's right.
Yes.
I'm surprised more than anything, knowing that would probably capture a lot of attention, that her lawyers didn't push her harder to calm down, but we all know how celebrities can push the bar on things. So, we've had a couple more participants join. Just again, want to acknowledge, we know you're there. We're just going to give it another couple minutes. So we're just having a little pop news chit chat.
You know, one of the things that Lauren always says, and that's important, especially in the context of celebrity divorce and clients asking for something, asking for their lawyers to, you know, file a lawsuit or go into court requesting certain demands. And there's a lot of pressure. We are advocates for our clients, and at the end of the day, they are the decision makers. But if you don't have a lawyer pushing back and saying, like, this is not going to go well for you, this is a waste of your money, this is a waste of your time and energy, then you really need to evaluate the advice that you're getting.
Yeah.
You know, and if you find that you're in the driver's seat and you have your hands on the wheel and your lawyer's just doing what you're telling him or her to do, then that's probably a pretty imbalanced dynamic that you may want to recalibrate.
Yeah. So people don't like to be told no, but that's sometimes in cases like this exactly what you need, right? And that's why they hire the professionals. So, you know, I just want to say thank you to everybody who's joined. I think we'll probably have a couple more people get on, but, you know, these coffee talk sessions that we're doing, they're really meant to just provide expert education on divorce, family, and matrimonial law topics. Help everybody kind of get to know Paige and Lauren. And we just want to make sure everybody knows that they're always open to past, present, potential future clients, anybody who just you think may have interest, and they're free to attend. All you need to do is register. So anytime you see a topic come in, we encourage you, whether it's you or somebody you know in your life who might benefit from it, please encourage them to join. We will also be posting, we are recording this session, and so we will be posting it on our website, on our blog afterwards. And please, you know, we'll let everybody know that it's posted, and please feel free to share it as well. Why don't we go ahead, and just in case there's anybody on the call who has not formally met everybody, we have Lauren Artesi, partner, and Paige Zandri, managing partner of Artesi Zandri, and I'm the director of operations, Julie Kauser. We are going, the session is set up to last about 20 to 30 minutes of us, you know, talking about the topic, and then there is a Q&A. So anybody who would like to ask a question, please feel free to just pop that question down in the Q&A icon. You just click it and then type it in, and we'll either address it. I'll try to weave it in as we're talking, or we'll address it towards the end. So please, that's what this is all about. We want people to feel like their questions are being answered. So, we were just talking about, for those of you who joined a little late, we were talking about Mary Kate Olsen trying to file for an emergency. And, during times like this right now, we know that the courts are working at a diminished capacity. We've been talking a lot internally at the firm about what deems an emergency, what people can do during this time. And one of the things that we realized a couple weeks ago that we were discussing was that there's a lot of people who have received, a sudden and unexpected loss in income. And one of the things, due to COVID and things being shut down, maybe they've been furloughed or lost their job altogether. And this can really impact somebody's ability to continue to pay their child support obligations. Obligation, though, being the key word, and how you can make sure that you're continuing to take care of your obligations while also setting yourself up for a potential modification in the future. So with that, why don't we go ahead and get started? Lauren, I'm going to put this first question to you. The things are very much in flux. Can we just kind of at first educate the audience about where are things with the courts right now? Are the courts accepting any sort of filings or motions? Is there anything that can be done regardless of modifications or anything?
So it's changing every day. Since we, posted the blog to our website, it's changed since then. The counties are not all the same. There's been word that in New York County, you can start filing modifications at this time. The court is accepting electronic filings, which that is a recent development that just happened this week. And that is for non-essential matters. Beforehand, essential matters, you did have access to the court. It was difficult to get papers filed, but if you had to get papers filed because you had an emergency, you definitely could. On all of our cases, on all of our Supreme Court cases, because there's Supreme Court cases which involve divorces, and then family court matters which involve custody and child support issues for people who aren't married or people who post-divorce matters. So Supreme Court and family court's been a little bit different on who you could get access to and how quickly you could get access. But if there's an emergency and you need access to the court, you pretty much can get it. And we've been in touch in a lot of our cases in Supreme Court. And we've started over the last couple of weeks doing some virtual conferences. But in terms of new matters, it's still pretty difficult, and it varies. It varies from county to county in New York City. Okay. It is what it is right now. I think the courts are scrambling. They're doing their best.
So, and that's why I think this topic in particular is a tough one for a lot of people, because deeming a modification an emergency, which we'll talk about in a little bit, might be very difficult to do. But why don't we first talk about what is a modification in child support, and what are the qualifications to even qualify for a modification for child support?
So in terms of a modification, if you can, either party, the custodial parent, the non-custodial parent can seek a modification. You can seek a modification to have the child support obligation increased or lowered. So an increased modification is considered an upward modification. That's the terminology that the court uses. And a decreased modification is a downward modification. And pretty much the standard for it is there's three. There's passage of time, it's 3 years, of an increase for either party's income of 15%, or a substantial change in circumstances. And the loss of income is the loss of income can fall into the 15% category or the substantial change in circumstances. It depends. And I mean, in the current climate, a lot of people have lost their jobs, so that will qualify as a substantial change in circumstances.
What are some of the other, just for my own knowledge, what are some of the other instances that would be a substantial change in circumstance? Are there other things?
So it has a lot to do with income, because you're talking about financial
Okay.
circumstances. You're talking about, the support, the financial support of the children. So the loss of income on either side, you can have the custodial parent who loses their job or has some sort of reduction in their income for a reason, and that could be a substantial change in circumstances. Obviously, if you have the non-custodial parent who has loses their job or has a reduction in their income for any reason, there could be a disability of either parent, an accident, something like that, which results in their inability to earn income at the level they were earning it when the child support obligation was set by the court or set by an agreement through the parties in their divorce settlement. So those types of things. There could also be an issue, with the child, where a child becomes disabled. There's an accident involving the child, and there's maybe more expenses now, and the financial situation of the family has changed. And those are different types of issues. But it has to be, for substantial circumstances, it has to be pretty serious. And there has to be either an inability to earn the income on the part of the non-custodial parent who's making the payments that was by no fault of their own. So if you quit your job, and you go in to seek a downward modification, you're not, it's not
likely
not going to be granted.
Yeah.
And if you're fired for cause also, that could also prevent you from getting downward modification.
So I just want to make sure I heard before, and I want to refocus again on it. I think you said something about a 15%. Is it a 15% loss or increase one way or the other that can help? It has to be at least 15% difference. Is that correct? Yeah. Okay.
Yeah, that's, and it just changing a 15% change in either party's income.
Okay.
Yeah.
What sort of support documents does a court even look for to see that change? Does there need to be a certain amount of time that has to go by when that change happens for them to even consider it?
I think it depends on the circumstances. If you're laid off from your job and you come in and you file a petition for a modification, for a downward, and you come into court, the court is going to inquire as to what you're doing to secure, new employment. I'm trying to think of like some specific examples from cases that we worked on. When an industry changes, we have a lot of people who work in the telecommunications industry, which is changing rapidly all the time. Mm-hmm. And there were positions where people could make a nice living, as technicians and things like that, going out and doing work. That's not really such a demanding job anymore,
right?
Because of cell phones and like towers and the technology is changing. So I've had clients who have worked in that industry and have come in for a downward modification. They used to get a lot more overtime, and they can't get that overtime anymore because there's not the demands. So it's that type. You're going to have to prove to the court that you can't earn the same kind of income that you used to be able to earn.
Yeah.
Or you could also seek a reprieve, a period of time. And what happens, I think, under those circumstances is the court will give you a temporary order reducing the payment, and then the matter will be adjourned. And, the court will say, depending on your circumstances, you go out, see what you can do, show us your efforts, then maybe we'll do a fact-finding or hearing to determine, that you can earn that much money and we'll have what you were earning prior. And then there'll be a final order. So there's a lot of different moving pieces that go into it. But the reality of your situation is whatever your original child support order is, in order to have that reduced by the court, you're going to have to establish that you can't earn that income anymore.
Right.
If it's a temporary setback, then, the court will give you a temporary, order reducing it.
Okay.
Yeah.
So
did I answer your question? I'm sorry.
Yes, you did. You definitely did. No, you're good. You're good. Paige, knowing what under the best case scenario, like under normal circumstances, outside of pandemic shutdowns and court freezes, what would be the process? Where would somebody even start if they felt like they could be doing a modification?
Well, there are two tracks, right? You can take the track where you may run straight into court, and you could take another track where you really want to try communicating with the other parent. I think in our approach is always that no matter whether you plan to end up in court, and you will, the courts even like to see that you've tried to work this out privately. So the first thing you would want to do is speak to your attorney to talk about how that conversation should go.
Yeah.
And in this particular case, we're all going through some really tough times. So massaging that conversation is very important, because it'll often dictate your ability to come up with a positive outcome for yourself and for your child. So we talk about how that conversation might go, and perhaps, if the parties can communicate, we would advise the client on how to approach it. You want to be reasonable. You want to understand, and probably start the conversation by saying, I know this is bad news, and I know we're all going through tough times, and I need some help. I'm hoping we can get through this together. If that's sort of laughable because there's no bridge for communication with
Yes.
the other parent, then you probably will want to have your attorney reach out and initiate that conversation. But having a record of that outreach typically goes a long way if you do find that you have to end up in court. Now, if you do end up in court, you'll have to file a petition and serve it on the other parent. And right now, as Lauren mentioned, we aren't able to do that. So especially in family court, a lot of these child support modifications end up in family court. And even though the courts are now accepting, new matters on an e-file basis, it's not clear. The family court is not set up to do that. So we don't know when you will be able to do that. So we're still sort of in the situation in family law matters that we were in a week ago, where new petitions are not being accepted. And so the question becomes, do you prepare that petition and just keep it ready for when the courts do open, while you are trying to have that conversation? And that's a strategic decision to make. If you are going to go that route, you really do want to have very good documentation, because transparency is critical here. When you do file a petition, you'll have to submit with it a sworn statement of net worth. That opens you up to perjury if you are not truthful. So they'll want to see, if you've lost your job, if you're in the unfortunate circumstances of having lost your job, and perhaps you're collecting unemployment insurance, unemployment income, you'll have to disclose that income. And just like how you prove to, when each time you make a claim for unemployment, you have to show your efforts to become employed, you want to preserve those records also for when you do end up in court. And one of the things about filing your petition from a strategy perspective that's important is that petitions for downward modifications or upward modifications, if and when they are granted, those are granted retroactive to the date of filing. So having that petition prepared can be important for when the courts do open up, because you want to try and get the date as soon as possible, to get that retroactivity.
But let me, if it physically, when you say, for clarification, when you say filed or the petition ready, is it, I've got the petition ready with my lawyer, but it's not physically put into the courts yet? Are those two
correct.
different things? So if the courts aren't opened up for another 2 months, even though you filed it, there may not be a retroactivity. You don't know yet.
Yeah, no, and I love, Lauren, for you to chime in here. I mean, the courts only have the authority granted to them through the laws, the legislative statutes that give them the ability to apply that retroactivity, and it is from the date of filing. So even though you have it prepared. And some professionals may advise go ahead and serve that petition on the other side.
Which you can do.
You can do that. Yeah, you can do that. But it's the date of filing with the courts, which is not yet an option, that gives the courts the authority to apply that retroactivity. So right now they do not have any legal basis for applying retroactivity before that petition gets filed.
So in listening just to what you're saying, regardless of whether it's now in the situation that we're in or in the best of circumstances, the biggest number one thing is communication. Communication is so important. And right now, especially communicating just what would happen if I just can't pay? Like I'm freaking out. I don't actually have the money to send my child support. It's stressing me out. It's what do I do beyond?
You have to talk to your attorney, because you don't want to just stop paying. You want to do the best you can do. If it's $25 a month, make it $25 a month. But let's go through the numbers. And because that's going to be part of the record if and when you do end up in court. And if you've shown that you actually do have an ability to pay, which will come out, and you haven't just because you are having a reaction to the fact that your financial situation now looks very, very different, then that's going to weigh heavily against you. So you are responsible for financially supporting your children. And if you are in a financially dire situation, we have to come up with a way to find out what is the best we can do right now. And then to your point about communication, we have to be transparent about what that situation is with the other side. And that's the best way to be able to get some sort of agreement and some sort of dialogue going with the other parent who now you need some help from. I mean, let's face it, the reality of the situation is not here's what I'm willing to do and take it or leave it. You're essentially asking the other parent for help, because they have to make up the shortfall. And so we should be smart about how that conversation goes.
Yeah. So communication, transparency, documentation.
Absolutely.
Three things. Lauren, you were talking earlier, before we even started the conversation, we were talking about emergency filings. Is there any case where a modification could be considered an emergency?
So there are, because in terms of modifications, when you're talking about modifications, you can modify, all orders, any order of the court, you can go in and seek a modification if you have a basis to seek that modification. So in terms of custody, the court does hear applications for emergency relief on custody matters consistently and regularly, I would say. Generally, child support matters are not seen on an emergency basis. In the normal course of things, what would happen is you'd go to your attorney, you'd say, I lost my job. You'd prepare the petition, gather the evidence, and go in, submit the petition or the application if you're in Supreme Court, which would be a motion. You would file that with the court, and you'd get a court date within the next couple of weeks. Obviously, that's not happening right now, so it's a little bit different. But because because it's going to be difficult to establish the emergency element of it, like what's the emergency? Is there the threat of immediate harm or physical injury to somebody? That is an emergency. Is there a threat? The possibility that you would become homeless? Okay, that would be an emergency. But when you lose your job and you're filing for a downward modification, are you going to become homeless within the next 6 weeks?
Right.
Probably not. So because in order to establish an emergency before the court, you have to submit, a separate affidavit or affirmation to the court outlining what the emergency is and what what's the immediate harm and irreparable harm that will result.
So what I'm hearing from you is that basically we're going to go back to the number one thing is communication, because you're going to waste a lot of time trying to even get an emergency. Like you're better off trying to continue that communication level, use your attorney to help if you can't do it yourself, because it's not realistic that an emergency would be heard.
Yes, and at this point, in the world that we're living in right now, being that the courts are operating at a diminished capacity, the courts really need to be focusing on the matters that, if they are not heard, there will be immediate and irreparable harm to the family. So, your position before the court weighs heavily on how the court perceives you and sees you.
Yeah.
So if you're coming in on an emergency because you lost your job, and the court has other matters.
Yeah.
That rise to the level of an emergency in their eyes. If yours doesn't, you kind of lose some credibility. So, and I think I don't know, there's some people who may have joined who were not here for the beginning of our conversation when we were discussing Mary Kay Olsen. And that's the harm to your matter that can come if you go in and allege an emergency, and the court is determines that this is not an emergency. And under the current climate and the current circumstances, to do that, we wouldn't advise it. We've been counseling our clients and telling them, you guys, you got to work together. Even in our highly contested matters, you got to do your best to work together for your kids. In the long run, that's what's best for your case. Obviously we monitor everything and we're there for them, and we, maybe do a little bit of counseling beyond just the legal matters, and just as, take care of yourself, obviously, go scream into your pillow.
That one always works for me.
You do have to put your oxygen mask on first before you can save anyone else.
That's a great analogy. That's a great
analogy. Yeah. But what's been interesting throughout this shutdown is that parties have been forced to communicate, wherein in the past they've been able to avoid that because the courts have been open, and they've just resorted to that as their first course for remedy. And this is, I always recommend mediation where possible, and we're finding that building bridges between the parents has been possible without having an opportunity to go anywhere else. They're forced to communicate, and it's been helpful for not just the parents to be able to work out their issue on support, but also to be able to co-parent and for the children to see that their parents, are able to work together. It creates a great model for the kids to be inspired by, throughout all of this turmoil. If parents are able to, if parents are able to communicate, what a blessing, what a blessing for children to witness that in the midst of all of this chaos. That would be such a silver lining in a situation like that.
Well, because that's really what it's all about at the end of the day, is the children.
That's right.
That's what it's all about. Lauren, something you said before also spurned off in my head. We've been talking about, I lost the job and I'm the one who's supposed to pay. What about if I'm the one who has I'm the custodial parent, and I've lost my job, and which now is affecting how much I need from that? Is that considered a modification too?
Yes. So that would be, the custodial parent would be seeking an upward modification through the court system under those circumstances.
Got it.
And, that is something that, that happens and occurs. Generally, how it goes is that the custodial parents are the ones seeking upward modifications, and the non-custodial parents are seeking downward modifications. That's just generally how it goes.
Right.
So, because the non-custodial parents are they have a separate household that they have to financially cover and support, and then they also are giving the custodial parent their obligation for the month, and then in addition to the basic child support obligation, there's oftentimes add-on expenses that, depending on the age of the children, can be also a substantial amount of money. Childcare. I'm having a brain fart right now. What else is it?
Unreimbursed medical expenses. And in times
college,
like these,
sometimes college,
Right.
So, so that parent can, but we're under the same, they're under the same restraints that the non-custodial parent is. You can't get into court. So it goes back to the same thing that we've been talking about. Communication. You got reaching out and saying, listen, this is my situation. This is what is happening right now. This is what I need to get by.
Yeah.
Is there any way that you can, help me out, give me a little bit more now? And you can enter into an agreement, and you can have that done, through attorneys. So it's notarized. But you also, if you don't have the opportunity to do that, having email correspondence discussing these matters, and then having proof of payment, if you ultimately have to end up in court, those are all great things to have. I mean, I would never advise a party to, a situation like this to have just an oral agreement. If you're not going to have a legally, executed agreement that's done through attorneys, I would advise to at least have some email correspondence in writing. That's even better than text messages. Text messages are okay. You can present them to the court, but I think an email is obviously something better, and you can get more information in there. So you just want something to show the court that this really happens, because if it's an oral agreement and your communications with, your children's other parent breaks down, then it's a he said, she said.
Yeah. This also, I'm also thinking about in some like worst case, very contentious scenarios, putting myself into the mindset of a potential client. What happens if my ex, who has, primary custody, is not allowing me to see the children because I can't afford to pay, and they're threatening not to let me see them until I can pay again? I mean, is that even allowed? Can they do that?
Absolutely not. Child support and custody matters are determined separately. They're not contingent on each other, and the custodial parent should not be engaging in that type of behavior. It's not what's best for the children. And as we just discussed, what's the court's primary, and not even primary, the court's only concern in these matters is best interests of children. They don't care about what's fair to the parents. They're going to put that into their considerations, I'm sure, because it all wraps into the best interest of the children. But, you hear a lot of parents saying it's not fair, this is not fair, that's not fair to me. And that's not the standard. The standard is best interest of the children. And obviously the children being financially supported is a best interest element. But each parent having access to the children is also a best interest element. So the law in New York is pretty clear on this, that, there's case law that has outright said that a custodial parent denying access of the children to a non-custodial parent is per se evidence that it's a per se basis that the custodial parent is not fit to be the custodial parent, and that could be a basis to change custody. It's that the
that's
courts
huge,
are
then.
that adamant about access of both parents to the children, and to interfere with the other parent's access to your children based on their failure, inability, or if you want to say unwillingness to pay child support, is not acting in the child's best interest, and you should never do that. We would advise our clients strenuously not to do that. And it would be a problem for us if we had a client doing that.
Well, that's good. That's good to know. It's not allowed. I'm sorry, Paige, go ahead. Were you going to say something?
Yeah, I just want to tie it all in. If at that point, if you are the parent who is alienating the child from the other parent because of their inability to pay child support, guess what? If you lose custody of the child on that basis, you're going to be paying child support to the other parent.
Yeah.
I mean, that's like a double whammy, that's really just the worst possible thing you could do.
Yeah.
I know this is a little bit off topic, but I'd just like to say, because it's something that I feel very strongly about, in my experience in working on these types of matters, the long-term negative effects that alienating your children from the other parent have last a lifetime. It's into your adult children will have like negative impacts in their lives because of that. It's one of the worst things that you can do to your children.
Well, and I think we're going to be touching on that in an upcoming future topic, right? On social media and disparagement and alienation. I have one more question before we see if any of our attendees have any questions. And again, attendees, if you have anything that you'd like to ask, just click on the Q&A icon down at the bottom and shoot it in, and we'll address it. But one of the last questions I have is, I'm somebody who likes to get ahead of things. And if I can prepare, I am gonna prepare every which way. Is there any way to even prepare for something like this during the initial divorce proceedings, knowing that there's all sorts of things that can happen in the world? And maybe I want to make sure I never even have to worry about whether I'm going to have to be concerned because of a temporary job loss or something. Is there a way to even prepare for this in the divorce proceedings to begin with?
That's a really, really great question. And what we are seeing more often, especially since 9/11, are that we're dealing with what's called now catastrophe clauses in divorce settlement agreements, so that if, God forbid, something were to happen that rises to the level of catastrophe, we have, we sort of have a plan for that, a plan for how to deal with that. And those are being invoked during this pandemic shutdown. So there are ways that you can plan ahead, and you have to be very careful about how you craft that language, because it's not unlike your insurance plan and what type of coverage you have and how that language is drafted.
Yeah.
What is a catastrophe? How is that defined? And you have to work with the other side on coming up with those terms.
Yeah, things change all the time, right? I mean,
all the time.
All the time.
No, and we have a client who it allowed her to take the steps that she needed to take to keep her son safe in these times. And,
interesting.
Without the conflict, without the issues of a potential emergency filing happening based on access, because it was laid out in the agreement what amounted to a catastrophe. I mean, and I think there's no argument that it's a global pandemic. It's going to change the way that we live our lives going forward. And I don't think anyone would argue that it's not a catastrophe, but the what was laid out in the agreement, informed her decisions and gave her the ability to,
right.
Protect her family.
Right.
There's one other thing I want to say. Sorry, Lauren, please finish.
No, go ahead. I was finished.
But one thing you might see more commonly is that parties will often, Lauren talked earlier about the grounds for seeking a modification, and there are three. The first is a substantial change in circumstances, passage of 3 years, and a change in gross income by 15%. A lot of times, just to build in certainty in terms of moving forward and being able to rely on child support payments, the parties will waive the passage of time and the change in income of 15% in their agreement, and that is allowed. What they cannot waive is whether or not either of them experience a substantial change in circumstances. And to Lauren's point, a drastic loss of income would qualify as that. But the reason why that cannot be waived is because that protects the best interests of the children, right? So the courts you cannot take that away in an agreement, negotiate out of an agreement protecting the children's best interest, because they are not a party to that agreement, and the courts will not allow you to take that away from them. So when you have a substantial change in circumstances, it's often viewed through that lens, and that's why it gets preserved.
All right.
Yeah, even if it's listed as waived, it's you're because I've seen that in divorce agreements where you waive all three of them and you can't. So
you can't.
Yeah.
I think that's an important point. But that plus the catastrophe clause, which has become, I think going forward, that's part of our punch list after this pandemic. When we're drafting agreements, it has to be.
Yeah. Yeah, it's times this is definitely going to be changing all sorts of things in our lives, right? Some of it for
Absolutely.
the good. I mean, what sometimes you're forced into making changes, and just has to happen. For any of our attendees, if anybody has any questions, feel free to shoot them in now. Lauren and Paige, are there any things that you feel like we did not cover or I didn't ask that you think people should?
The other.
Oh, sorry. There was one thing when we were discussing continuing to make some sort of payment, even if you can't make the full obligation because of the loss of income. And I don't know if everybody completely understands, what income is and how child support is measured. So if you've lost your job and you're getting unemployment, and I do think Paige mentioned that you have to disclose that because that's seen as income. And I know that anyone who lost their job and has bills that they have to pay, which is everybody, you have bills you have to pay, they're probably thinking to the future. And when unemployment becomes unavailable, you're like that, they would maybe be considering that, I still have my mortgage and all of that stuff. The courts wouldn't consider that in your, as long as you're getting that unemployment, you should be paying in accordance with your income, not in accordance with that your income could be ending, in a few months. It's a month by month obligation that should be measured by your income that month, in my opinion. Because if the courts are, if you go in and you say, well, I had to save that money because I knew it was going to end at a certain date, the courts are going to say, well, so your children had to suffer and not be supported because you were worried about that end date. Like, it really should be a month by month obligation, and you should be communicating with the other parent, because maybe the other parent can say, okay, like, we're in a position where I'm okay, I'll agree to let you, you can pay $1,000 instead of $4, say that's what your obligation is. And based on your unemployment, you really should be paying more. Right. It's okay if they agree to it, but you really want to protect yourself in terms of your intention, your motivations behind what you're doing. The court wants to see your motivations to always be based on what's best for your kids. And they definitely are going to consider your struggles and your bills. The courts do not want to issue child support orders that make a party destitute. Like, that's not what their goals are. So it's, really planning,
It's so important to not be opportunistic, because we can guarantee that if you get a downward modification either through the courts or by agreement with the other parent, and then you begin making more money, there will be an upward modification. And you should definitely keep that in mind when you make decisions and when you act or react based on certain motivations, because that will come around to bite you in the end. If you acted in your own self-interest to the detriment of your children, and then you find yourself in the fortunate position of recouping income and getting back on track, that's going to come back, and you will be subject to an upward modification. Okay. So that's all the more reason to try and work it out outside of the courts, because those things, they take time and they take money.
Well, yeah,
that's money out of your pocket. It's money out of your children's college fund.
I think it's also going to be safe to say that even when the courts reopen, right, that there's going to be a backlog. So you need to try to figure this out. Use your communication skills. Lean on your attorney. Just communicate, transparency, documentation. Do not stop, though, altogether.
Yes. Correct.
Do not stop altogether. That's the worst thing you could do.
Yeah.
And I don't know, Julie, does anyone have any questions?
No, not. I think I hope we've covered everything, if that's what that means. We don't have any questions today.
Well, so there was one other thing then I'd just like to say,
okay.
To address.
Yeah.
We're talking about like the retroactive orders that the court can grant, and that they're to the filing date. So Julie, I think you just said this is changing. This pandemic is changing so many things, and the courts, I do think, have done their best to protect individuals because of their inability to access the court. You know, they've suspended statute of limitations, they've suspended deadlines for filings, and things that could prejudice a party if, you know, they're in, because they're unable to get into court, because they're unable to file, and things like that. So we don't know exactly what's going to happen in terms of the retroactive, you know, the abilities of the court to go beyond. You know, the law could change. We're going to have to see what happens once we get into court, and, you know, how people have been impacted, and what their ability to continue to support their children has been, what, you know, what financial damages have resulted, and it's going to depend a lot also on the economy.
Right.
You know, I don't think that anyone would disagree with the fact that people who are being laid off may have a very difficult time securing employment, making the same money that they were making, you know, prior to this pandemic. Yeah. And, you know, I believe that the courts are going to be very fair in their assessment of, you know, of your ability to earn the same income. So, you know, if people, I just want to comfort some people if they've lost their job and they're feeling afraid, and they're feeling as though, you know, they're never going to be able to pay the support that they had agreed to pay and are court ordered to pay. You know, there will be relief, and we are going to advocate for you, and we're going to go into court and fight for, you know, the retroactive orders to go potentially beyond the filing date because of your inability to file. You know, I believe that all family attorneys are going to be making similar arguments to that if they have clients who've lost their jobs, and we're going to have to, like, you know, see what happens. But we're all in this together, and we want to make sure that you guys have access to the information you need to make the best decisions for your family. We know how hard this is. Like, we know how hard it is to co-parent under these stressful times, and how difficult it is to be afraid for exposure for your children. And, you know, you have a lot of blended families, and, you know, it's really hard. And, you know, we're here for you, and, you know, we just want you to have the information that you need to make the best decisions for your family.
Yeah. Well, and I would also stress to everybody that Paige and Lauren, while they are not physically in their office over by Penn Station, they are actively on email. They're answering the phones. You definitely reach out to them, please, if you need help or you know anybody who needs help. They are here to answer your questions and help you through what's a very difficult time. So I have nothing else to ask. Do either of you have anything to add?
No, thank you.
Yeah, good. All right, well, guys, we're going to be doing another one in a couple weeks, and it's going to be on social media and social media and what you should and shouldn't do.
Yeah. How it impacts your divorce proceeding.
Yes, how it impacts your divorce.
Or custody.
Yes.
You know, it doesn't have that much impact on child support, but it very much can have an impact on custody matters. So
awesome.
It's probably, and it's interesting. So if you guys are interested, definitely tune in.
Yeah.
We're going to be talking about a recent decision that could have some implications on it. You know, so
it'll be a good one.
Come back and join us.
Yeah. All right, ladies. We'll chat
Take care,
soon.
everybody.
Thank you, everybody.